Yep. Okay. Go!
Will you hand me my screen box?
Now go. Preach.
All right, we're going to go on the record in the matter of the marriage of Phillips versus Blake, 18 DM 5. Mr. Phillips appears through counsel.
He is present also.
Okay.
He's just out of the frame.
Very good. At Mr. Brazil's office, we have Miss Hawkes. Is that it? Hawks?
Miss Hawks, yes.
With DCF.
That is correct.
Because this is still a 4D case. And then Ms. Blakey is present with, who's with you, Ms. Blakey?
This is my case manager through South Central Mental Health.
All right, very good. All right. I think there are some motions as they pertain to child support or a motion to enforce custody order agreements, I guess is how it's framed. But I think the child support maybe predated this other motion. Ms. Hawkes, do you know where are we, or Ms. Hawks, I'm sorry, where we are at as far as you all's position with regard to child support in this case with Judge Murphin, which has been sort of separate somewhat from the custody?
Your Honor, it's my understanding that father has a child support obligation of $342 effective December 1st, 2024, and that we've been doing a dollar for dollar offset for the arrears that were owed by mother. And I believe that's about to be satisfied. And that we were just here today on a review of that order.
Okay.
Whether it would continue.
Okay. That is my recollection. And remind me, Carvin is how old now? He was 6 when we started all this, or thereabouts.
Is going to be 16 or 17, excuse me, in August.
17 in August?
Yes, ma'am.
Okay. And will he graduate this next school year from high school?
No.
He won't. So he's going to be a junior?
Yes.
Yes.
And he'll turn 18 as a senior?
Yes.
So instead of just having 1 year left of child support, there's 2?
Yes.
Mr. Brazil, from what you can ascertain with regard to, and by the way, Ms. Blakey has for most of the majority of this case and currently been pro se or self-represented. So this, and she's filed numerous motions on her own. This is a notice of hearing and motion to enforce. Mr. Brazil, do you feel like you have a handle on her motion?
Yes, Judge. I think argument is probably fine. I will say, and I would proffer to the court that my client visited with the police that reported to his home that evening, and none of them had any concerns regarding anything like intoxication. And so if we really were going to get into it and have to deal with that question of was he intoxicated, was he not, then I would ask for it to be set for evidence. My hope is that that's not necessary and we can kind of resolve this motion and move forward. I think ultimately the bulk of her motion is more of upset with how co-parenting is going and less of, the specific request for the substance abuse or things like that. I'm kind of a little wondering if this was like an AI generated request. I don't have any real reason to believe that that was necessarily there. Just the formatting and things like that seem like it might be a ChatGPT generation.
All right. Ms. Blakey, I'm not familiar with that stuff yet enough to hopefully after our October training, maybe a little better at recognizing some red flags, but I'm not at this point. Ms. Blakey, would you please summarize for the court your motion and your requests or prayers for the court with regard to this motion?
Yes. Are we gonna deal with the child support after or first?
We will at some point discuss
Okay.
it. For now, that's the main thrust of this is the motion that you filed on June 5th.
I have written down what I'd like to say. I did my very best to shorten it and stay respectful. So I'd like to say on the record regarding my motion. At a previous hearing, Your Honor reminded us that when things escalate or break down, we are to seek resolution from the court. My intention is not to punish or shame Chad, rather to improve the health and function for all three of us. I filed this motion out of concern, distress, and need. The need for health, peace, safety, and boundaries. The need for support, protection, and accountability. It is my responsibility to advocate for Carbon and for my family. Part of the evidence I've submitted includes a list of medical appointments in order to make known the patterns I believe reflect Chad's lifestyle choices and have compromised his reliability. I believe his longstanding issues with alcohol and personal habits are interfering with his ability to meet Carbon's needs consistently and safely. To my knowledge, Chad has not scheduled or attended one medical appointment since the custody change. Not even when Carbon is in his care. Chad relies on me for all of these needs now.
What
Due to
are you relying on?
me for the medical appointments.
Right. Because I remember very distinctly you wanting to be involved, make appointments, go to appointments, be part of things, and you got your wish granted, right?
Yeah, and I don't mean to be rude or pushy, but if I could finish what I've written down, it's
All
really
right.
it's important to me that I convey all of this.
All right. Well, I'm trying to take notes here. So one of your issues is that you now are the primary person that schedules everything.
Well, I'll finish.
All right.
Due to this event that based on the motion that I filed, a friend suggested that I should not be compensating for Chad's lack of involvement, and I do agree. But when Chad suggests instead to allow Carbon to drive into Wichita alone for the appointment before he's ready to drive on major highways, or for the appointment to be pushed back to accommodate Chad's tattoo clients over Carbon's medical care, or altogether not provide medical care, I cannot stand for this risk or the neglect. If I'm being honest, I do cherish having these moments, these appointments, and this time with Carbon. But I do think that Carbon needs both parents. And if I'm going to be the only one tending to the appointments and other needs, I would at least ask Chad to have a respectful conversation with me instead of lashing out when he has issues, if there's a disagreement. Perhaps Chad feels he's giving us this time out of kindness, the appointments. Perhaps he's relieved to have less responsibility. Whatever the case, I just cannot tolerate the intimidation or the aggression that I experienced during this event. What other people see is a version of Chad that he chooses to show publicly, a kind, successful father, but I'm asking the court to acknowledge that I am on the receiving end of a very different version. There are moments when I am looked at and spoken to by Chad with such deep disdain and contempt that I cannot help but feel unsafe emotionally, spiritually, and physically. I'm almost done. This is a reality I've lived with silently for years, and I did not ask for this. I've asked for peace and health. I shouldn't be expected to suffer in silence or with unknowing that I have no clue if Carbon is in danger behind closed doors with Chad. All I know is that Chad's words do not align with his actions, and no one can convince me that I shouldn't be afraid in these moments. My heart, soul, and intuition knows what it knows, and I know these situations are not right, they're not healthy, they're not safe, and they're not okay, and I can no longer allow these things to happen, and that Carbon and I should no longer endure these outbursts or this addiction. Most importantly, you all must know that through all of this, I do not hate Chad. I want peace for him and with him. I pray for him to heal and find joy again, to be present and whole for Carbon. Hatred is too heavy a burden to carry, yet it is inflamed by the bottle. My hope is that by bringing this to the court, we can restore healthy patterns and clear, respectful communication. This motion is my attempt to enforce and uphold the structure and expectations that the court has already put into place. To provide Chad with help that I do not believe he recognizes he deeply needs, so that Carbon is not absorbing and navigating the dysfunction. Carbon should not be the go-between. He should be free to be a teenager, not a mediator. He deserves a peaceful environment to feel safe in both homes, and that's what I'm asking for today. I believe that with an alcohol assessment and therapy together with Chad and myself, this peace can be achieved. I need the court's help with this because I'm willing, and most importantly, because Chad or Carbon needs it. He needs us. Thank you. Basically, I'm concerned with Chad's drinking, and I do worry about Carbon's safety. And I'm not trying to take anything from him. I just think that he needs help because these outbursts are deeply affecting Carbon and myself. And I'm really just concerned about the drinking, and I would like for that to be looked at. And I'm very willing to have therapy with Chad so that we can have a healthy co-parenting relationship.
I know there is co-parenting classes now with like counseling with parents, but it's in Wichita, and I think you guys are so far down the road now that I'm not sure that that is a real genuine solution. But I do want to hear from you, Mr. Brazel. So in response.
Yes, just a few items. At the top, as I said earlier, if the question of whether or not there was intoxication is kind of a central point of the question or what we're looking at, we would ask that it be set for evidence. Again, I would represent to the court that my client did talk with the police when they came to his home that evening. They had no concerns for intoxication. If they did, I think we would have potentially heard about it. Mr. Phillips has never been arrested for an alcohol-involved anything. No DUIs, no anything other than Miss Blakey's blanket assertion that she thinks he has an alcohol problem. And that, frankly, is not any type of evidence. One of the things that we've kind of highlighted or talked about in this case as an important thing to avoid conflict is using Carbon as a mediator or source of communication. I think that's been Miss Blakey's complaint, is that Mr. Phillips will talk to her via Carbon. And a large part of what got us here, this incident on April 29th, was because Miss Blakey did exactly what she complained of. She made a separate arrangement with Carbon to use his vehicle because her vehicle was not working, rather than communicating with Mr. Phillips, who is the owner of the vehicle, who has insured the vehicle, and who really should be the person giving permission about whether or not that car should be borrowed by somebody else. That's what led to this whole exchange and this whole conflict that Miss Blakey's citing or talking about. It is interesting that there is this emergency, or she talks about all of these concerns about safety, which occurred at the end of April, but then does not file her motion until June 5th. I think that gap in time is a significant concern. She talks about Mr. Phillips's willful violation of the court orders and talks about a few different things. The violation of joint legal custody, and then says that Mr. Phillips's actions are a disruption to the child's routine or creating unnecessary conflict. But joint legal custody is between parents. She says we're upset, or she's upset with what he's done to Carbon. But as between the two of them, there's no allegation that he's not trying to communicate. She's admitted exhibits that show he's asking her to take her to medical appointments. She now attends those medical appointments. He's upholding his end of the bargain. On these issue of all of this relief that she has requested, the order for alcohol assessment and treatment. Again, there is no evidence to suggest that he has an alcohol problem other than her blanket assertion that these things are the case. Talking about emergency protocols for respondent, that might be helpful only because this is not the first time where Miss Blakey has resorted to calling police to mediate a situation. We had a hearing, I think it was in last year, because she chose to call the police and escalate a situation when either Mr. Phillips or the child were not answering her calls. That is not an acceptable solution. Using law enforcement to do a welfare check when you unilaterally think something to be the case is not an answer. It was a problem then, and it remains a problem. The question about co-parenting classes or any of this, the main concern I have with this, number one, is that these folks have about 1 year left until this child turns 18. I think the court is correct in saying that we are pretty far down the road at this point. But the second concern that I have is that we periodically will come to court. Miss Blakey will have a series of complaints. The court will put orders in place to try and alleviate those. And unfortunately, Mr. Phillips is the only party that actually follows through and tries to bear the burden of those orders. If it's an order that Carbon goes to therapy, who's the person who did that? That was Mr. Phillips. If it was an order that we're going to try Lance Parker for case management, who goes and gets his evaluation? Mr. Phillips. Who makes sure that Carbon gets an initial interview and assessment? Mr. Phillips. Who doesn't comply and talk with Mr. Parker? Miss Blakey. So it's not reasonable to say that we need to do some other thing that she's ultimately not going to comply with. Thank goodness we reached a resolution and an agreement to do shared residential custody and had Mr. Parker hold things in abeyance. But it continually is a case where we come to court, Miss Blakey has complaints, the court tries to alleviate those, and then Mr. Phillips is the only person who really follows through on that. We would ask that the court just deny the motion outright and take up the issue of child support.
May I
I
respond?
do think, just a minute, I do think that this is the second time she's voiced concerns about intoxication. But truthfully, if you're going to bring this motion, Ms. Blakey, you're the one that has the burden of proving the truth of it. And so either through police reports or witness statements or Carbon's statements or something, there has to be some evidence here before the court that he has a drinking problem that is interfering with his ability to parent or provide for the child. There's nothing illegal in and of itself for someone to drink. And especially if he's not transporting the child's doing most of his own driving. But if it is to a point that he's making poor judgment, endangering the child, something of that nature, in the absence of a DUI or some kind of criminal conviction, which evidences a propensity to violate the law when consuming alcohol, then I can't just leap to a conclusion that because you've alleged that he has some serious alcohol issues, that he has one. If you have some affirmative evidence, because it's not their burden on the motion, it's yours. So You have to convince me that it's more probable than not that he has an alcohol problem that is interfering with his ability to parent. Video, police reports, witness statements, something for him to then have to defend the allegations. In other words, he doesn't have to come. You can't just make a mere allegation. He have to exert the effort and subpoenas and the money and the time to disprove a mere allegation. You have to prove up the allegation, and then he has to defend it. And that would be true in any court of law. Additionally, I could order that he wear a scram device for 30 days that makes sure he can abstain from alcohol for a period of 30 days. Or I can order that he get a drug and alcohol evaluation and the court review that. But again, I do think Mr. Brazil is correct in that at every turn in this case, he has paid for an attorney. He has paid to do those things that the court has asked him to do. He has taken care of the child with little or no financial support from you. And I don't think that the court has grounds today to just order him to do things that are going to cost him a substantial amount of money because you're alleging that he has an alcohol issue. So if you have some independent corroboration or some evidence, then let's have an evidentiary hearing where you at least meet your burden of establishing a prima facie case that he has an issue. But the way it sounds now, or the way it stands right now, it's a mere allegation. So it's up to you. If you want to move forward, it's going to be your burden to prove. I've never assessed attorney's fees in a case because of your limited funds, and quite frankly, you didn't prosper from the divorce itself in any regard that it gave you a lot of money to fall back on, and you only received limited spousal support. So I've tried not to burden you financially either, at times where they probably were warranted in asking for attorney's fees. So I'm not trying to threaten you with that at all. I'm just saying that you have to, when you bring these things forth, you have to have some evidence, or it arguably becomes, well, unfounded, which is grounds to request that someone pay attorney's fees. So I don't want you set up for that claim either. So that's why I'm asking you, do you want to move forward with an in-person evidentiary hearing where you will have to represent yourself and subpoena witnesses or documents or have some sort of evidence to establish that he is consuming alcohol to a degree that he is being neglectful, as you suggested, and or endangering the child or the child's relationship or ability to flourish?
Okay, I have a question, and I would also like the opportunity to respond.
Well, go ahead and respond.
My question is if I had emailed Amy asking if it was the appropriate time to submit my evidence, and she said yes. So I did do that. I'm wondering if you have that. I mailed it to Grant, and I filed it in the court.
I have received a copy of it, yes.
Amy, I don't see a notebook or any additional items here.
It looks like she filed it with the clerk and they filed it. I'm not sure why they would have filed exhibits in the court file, but they did, and it was done on 7/25. And it appears that,
Oh, they're not in the court file.
no, probably not, because I pulled the cases before that and I was not aware that they were filed with the clerk on 7/25. But there's 21 pages of it, exhibits A through F.
I will at least want to reference one at one point in time, and I can share screen to show that if that's what we would want to do. But Miss Blakey can.
Yeah,
by all
I
means
mean, I
respond.
need to know what they are that she filed that I didn't get. Yeah.
And not to be rude or complain, but this happened during the last trial where I submitted evidence. I worked very hard on it, and it
Okay.
wasn't.
Well, truthfully, this isn't how evidence is submitted. You don't just send it, it gets filed, I acknowledge it, and it's evidence. You have to come into the courtroom, you have to lay foundation, you have to move for admission, they have a right to object, and then I have to admit it, and I don't look at it until it's actually admitted during a trial process. Now, that's not to say that we don't have some domestic hearings where the standards are relaxed, where we let attorneys make argument, and if they stipulate to exhibits and or they proffer something, that I don't consider it. But I do understand that there is a rule when we're doing something by Zoom that if we're having an actual evidentiary hearing, that exhibits need to be submitted early in the event that they get admitted so that I have a copy. But they're not in any hearing automatically admitted. But I also will agree with you. There are times that attorneys bring notebooks. There's times that they email stuff at the last minute. There are times that the clerk gets things that doesn't make its way up to my office or in my court file. So I do agree with you that it happens, and it probably has happened before given the history of this case. But again, even if I had them, they're not automatically admissible unless it's a scheduled evidentiary hearing and it's introduced as evidence. So why don't you tell me, just don't go into any detail, but tell me what A through F is, starting with A, so I have a general idea of what you're wanting to be offered to the court.
Okay. A is phone calls where Chad asked me to take Carbon to a medical appointment that day.
I'm not concerned about, don't go into detail because it hasn't been admitted yet. You just give, like, if you're titling the document, what it is. That's all I need to know.
Well, really, the most important ones are that I had contacted the police. And the reason I added those is, well, essentially, why would I contact the police and put myself through all of this if I genuinely wasn't concerned and afraid? So I was just trying to prove that I did contact the police out of genuine concern. I would like to know, on the point of all of this being accusations, that I don't want to go through any of this. This is not easy on me. This is not good for my health. So the point of submitting, like, the police records is to show, you know, I did contact them out of concern, and that it's very hard on me. That's not an easy thing for me to do.
Okay, let's get back on track here.
Other
A is the phone call, which I don't think that they're not going to stipulate that that happened. I'm more concerned about the allegation that you're demanding that he have an alcohol and drug evaluation and or treatment or intervention. So that's what I'm suggesting that you need to prove. I'm not questioning that you don't continue to have co-parenting issues, because I'm confident that you do. But let's stick with what is B.
That's phone calls between Carbon and I when I tried to return the car. C is calls and texts between Chad and I. The reason I submitted that is because Chad repeatedly asked me to have Carbon call him instead of communicating with me.
Okay, that may be something significant that we may want to look at. I will tell you though, with regard to the vehicle, did you pay any money for that vehicle?
No, that's Chad's vehicle.
Okay.
It's in his care, and I'm not disagreeing about you know, that could have been handled better.
Okay.
But Carbon has control of the car. That's his car. And the conversation of how I came to use the car, you know, that's not really being considered.
Okay. Well, here's the deal. This is just straight up, very easy for me to say. You have to have permission from Chad to drive or use that vehicle.
I don't have a problem with that. And I would have been fine with telling Chad that, but he wasn't willing to communicate in a respectful and healthy way at that time. That's my issue. It's not my mistake of using the car. That could have been de-escalated instead of it being escalated by Chad showing up to my house on foot and trying to drive the car off drunk. That scares me. That's what concerns me. And
Now, did you call the police when he drove the car off, as you said, drunk? Did you call the police so they could stop him and give him a DUI?
So what happened, Chad walked to my house on foot, and when he got into the car, I went over there to talk to him because he was slurring on the phone. And when I walked up to the car, he got out of the car in my face, and I could smell the alcohol. And he was just kind of yelling at me, telling me to leave him alone, and he ran off. He didn't take the car. He just left the car door open and didn't take the car. When Carbon was expecting him to bring the car back, and he didn't. So, and then Chad wouldn't answer my calls. So I had, in order to try to get Carbon his car back, if Chad's not taking my calls, I'm forced to call Carbon and be like, your dad didn't, I still need to return the car to him. So he didn't take the car drinking. He just ran away on foot. I'm concerned here. So I called the police because I didn't know what to do.
Okay. Well, when the police got there, they should have noted whether he was intoxicated to the degree that you've just described.
They do.
Okay.
It's in Exhibit D.
I'm sorry.
Blakey has.
All right. Let's see then. We've covered A, B, C. Now we're on D. And tell me what D is.
Okay.
Mr. Brazel, are you going to have an objection to her Exhibit D being
No,
admitted?
We would stipulate to A through F. That they can be admitted. So this is the first page here, Judge. This is just the information. 428-924, the non-emergency call by Miss Blakey. This is the details of kind of what's going on. Dad's upset, walked there to pick up a vehicle, smelled like alcohol on State Street. The second page is where there's the brief officer narrative about what happened when they spoke with Mr. Phillips about 2 hours after the call.
All right. Would you read for me, please, additional comments? Because it's very hard for me to see. I apologize.
No, that's okay, Judge. It's I think these have been copied a few times, and that's probably partially my fault. Officer spoke with Phillips and his son. Both individual appeared to be content around each other. Phillips explained that he was trying to get his son's vehicle earlier in the evening so his son would have his vehicle for school. Phillips stated that when Blakey put a hand on his shoulder that he exited the vehicle and left Blakey's residence to avoid further confrontation. Officer did not find anything that would cause concern for Phillips' son. Blakey was contacted and advised that everything was okay. TDB 280.
Well, without the officer present to testify, we can't really ask him, did you smell alcohol? Did you have concerns? If you had smelled alcohol, wouldn't you have noted? I mean, my experience with officers over 35 years is that if there's the presence of drugs or use of drugs or presence of alcohol or use of alcohol, that's generally always noted somewhere in their report, because it brings to question sometimes the credibility of the user or the statements of the potential user. So is there anywhere in this report that he mentions that he observed the smell of alcohol or had reason to believe that your client was drinking?
The only note that I would say there's any reference to drinking or drunk or anything like that, or in these lines here, for example, that looks like there may be dispatch notes. That's like reporting person R. Blakey, phone number, address, officer address earlier, concerned about her son and dad. Dad tried to drive son's car drunk, 50-50 custody. And then another reference, I think, I apologize, on a prior page that is similar notes. Son's dad, very upset, just walked there, tried to pick up vehicle, smelled like alcohol. I think they are, again, dispatcher notes, maybe.
Okay, so that wouldn't have came from the officer. That would have been statements made by the reporting party to dispatch that were being conveyed to the dispatched officer.
I am assuming so, because this M.A. Nava person has multiple entries of like initiated, dispatched, en route, modified. But then this other little narrative additional comment section is this TDB individual. I'm assuming that in the nature of that writing is much different than the other writing that are kind of more dispatchy is not a word, but more of that nature than a full narrative.
All right. I mean, basically in these exhibit C, he's denying that he's intoxicated or driving drunk. You're insistent that he is and that you're worried about him. The police go out, they make no mention that they're concerned about intoxication. So I don't know how calling the officer into court in the courtroom under oath is going to change much, unless you know something I don't. But ordinarily, the police don't testify to much more than what they have in their reports. Occasionally they have independent recollections of things, but they're trained that if something's significant, they're going to note it in their report. And like I said, generally, if they think someone is under the influence of drugs or alcohol, they note it just for the sheer purpose of the potential credibility of the person. Even if they don't think that they're driving or driving drunk, as you put it. Now, exhibit E is what, Ms. Blakey?
That's his Carbon's dental records that I was just really made aware. Carbon had gotten his braces off, and then I was informed that Carbon did not receive regular dental care the entire time that he had his braces. This has caused a little bit of enamel damage to his teeth. And the reason I have included this is because during that time, that's when I was expressing that I didn't have access to Carbon's medical care, and I wasn't aware that this was going on. And I have added this because I feel that the addiction has affected his ability to parent. That's why I included the medical records.
Okay, well, you haven't proved that he has an alcohol problem. I mean, you haven't proved that he has an addiction. You haven't proven that. And E is a list of appointments from December of 2022 to September 19th of 25. I'm not sure what they established in the absence of the orthodontist testifying. The chart notes show a lot of sealants that he spent money on, which is not generally paid for by insurance, for quite a few teeth that should protect the teeth. Some of this has to do with dental care by the person wearing the braces. And so again, I don't see.
The first appointment that he went to his general dentist was November 2022. That's when they diagnosed he needed a tooth taken out and he needed braces. So he got the tooth taken out.
Hang on. You are not qualified to testify as to what these records mean. If you want to have a hearing somehow about the dental care that he provided and paid for to your son and that was inadequate, then you have to have an expert witness to say that there was poor dental care which caused him some kind of permanent damage, or bring this dentist in to tell me that it's in some way Chad was neglectful in the dental care of his child that's caused permanent injury. Where I'm not going to look at these records and you're not going to testify as to appointments and what did and didn't happen and what the doctor did and didn't recommend. That's just, it's not acceptable. Whether you're representing yourself or even if you had an attorney representing you, I would not allow you to do that. I would agree that communication is an ongoing problem for the two of you, but I am not, if I could solve that with every domestic case and every parent, I would have already done it. It appears there are car issues, and I'm going to make the ruling that the car not be used by Ms. Blakey unless she has explicit permission from the owner and person insuring the car, Mr. Phillips. Ms. Blakey, have you received an official response or Social Security disability?
No, I'm still in the appeal phase.
Okay. Mr. Brazil, if we switch these people to our family wizard, I think the cost is like $50 a year or something to monitor communication between parties and to use the wizard. And it does appointments and all of that kind of thing. I think there's that, or there's some other company that Sedgwick County uses on a regular basis. And I thought someone told me there is a grant program or something that she could apply, because as usual, cost is always an issue for her, not being employed. And so I don't know if she could apply for financial waiver, but we might want to shift this communication so that it can be monitored better through one of those formal programs that's designed for co-parenting communication issues.
I mean, I
You,
don't, I'm not trying to be difficult, and I do want to know that one of the main reasons I did this is during the last big court hearing, you specifically said that when things escalate, we should be coming to you instead of hashing it out ourselves. And that's all I really knew to do. My intentions with this motion are um, it's hard for me to say. You asked for this to happen. I'm just trying to honor that.
I'm not sure how I did
It,
that exactly. I would need the transcript, but I think it was another incident where the police got involved and Carbon was in the middle of it, and it got frankly kind of out of hand. And there had been some issues that led up to that could have been reasonably addressed. If I thought I could put you two in mediation so that you had some place to go with your complaints so that someone could mediate, I would. But again, you two are not candidates for mediation. So I'm not suggesting that the court isn't here to hear matters as it relates to the best interest of the child. However, again, no party, including Chad, can make any kind of groundless claims against you and just bring them in front of the judge. So I do appreciate that you are frustrated with the car bit, and I know that you can't transport. You don't have a car to do any
I do have a
transport.
car. I do have a car, and I apologize. I am not trying to be confrontational or rude here. I understand that there is law, you need evidence. And I'm not trying to argue. I do want to make an important note that when at the very beginning of this hearing, and please don't, I ask you not to say that I'm trying to rehash the past. I'm not. I'm just wanting to say that in the very beginning, Chad accused me of having mental health issues without any evidence. I provided evidence that my mental health was stable, and I still have gone through all of this. And I'm not saying that now because I want you to pursue this without any evidence. I just want to say on the record, I did endure all of this based on no evidence. And I'm not trying to seek punishment for Chad. The idea of going through a whole evidentiary hearing and trying to prove the addiction is honestly so much more than I feel I can handle. I'm just trying to do the right thing and bring to attention what I'm going through, whether or not anybody believes it. I know what happened, and I'm just trying to take the right steps. And when I'm accused of calling the police and escalating the situation when I'm just trying to do the right thing, it's very difficult on me. I don't really want to be going through this. Most of the time, Chad and I have a really um, easy time communicating. We've been doing really well. I think that trying to move us to some type of program to continue communication would be a heavy burden on both of us. I'm not trying to put more strain on this relationship than there already is. If nothing comes out of this, if you do not choose to do an alcohol assessment, okay, but at least it's on the record that I have these concerns. Whether or not anybody believes them, I do want it to be on the record that I am trying to do the right thing when I feel things aren't going so well. I don't want to cause more conflict by having filed this motion, and I'm feeling the way that it's going is causing more conflict. I just want Chad to be healthy. I just want him to be healthy. I don't want to be accusing anybody. And we could very well, if he would agree, we could just go and have therapy together. He's on an insurance that would cover it. South Central Mental Health would cover us to go into therapy. I just want health. I don't want a bunch of court proceedings on.
Okay. Well, I know that this file is very thick with lots and lots of motions and different pleadings and things that you filed. And it's not a matter of what I believe or I don't believe today. It's a matter of you have a burden of proof. And I also have evaluated each stage of these proceedings, including a very long summary that I did of this case at one time. Experience the ebb and flow of the case and the transition of the parties. And I might add that you are doing very, very well. And I'm very pleased with that. And I am very pleased with, I don't know how much progress the two of you have made, but the fact that both of you are involved in Carbon's life in a manner that is not destructive. Now, I do understand that you believe that his alcohol use is overflowing into his relationship with Carbon. I do think Carbon is old enough now to tell me that at almost 17 years old. I do know that the time that I believe you went to the bar and things escalated, there's no question he had been drinking at that time. But whether or not he was to a degree that he was incapacitated in this case, I don't know. But again, I can't just order him to go perform a bunch of tests and pay for them because you're worried about him or you want him to. So that's where things sit right now. I do believe, though, if he has the pattern of abuse of alcohol that you're suggesting, that I believe you genuinely believe to be true, that it will surface. I mean, he will lose customers, lose a job, get a DUI arrest. It will eventually come to light. And he knows whether or not he has an issue, and he knows what he's doing. And he can either voluntarily address it or not until there is some actual independent evidence or indication that he needs court intervention as it's related to the custody case. But I don't think that day is today. I do want to address, though, two things. I already addressed the car situation with you, and you appreciate and understand that. And I doubt I'll have to speak of that again. But the second thing that I want to address is, again, to admonish the parties that communication shall be in a respectful, courteous manner, not excessive contact unrelated to the child. There's a new formula. Help me with this, Mr. Brazil. It's brief. It's BIFF, I think. Brief, informative, friendly, and another F word. I don't remember what it is, but it's a new sort of acronym. What?
Firm, clearly state your position and boundaries without being aggressive.
Yes. Yes. Brief, informative, friendly, and firm. That's how things are to be communicated. And The only way that I can help you, Ms. Blakey, is by a program that tracks all of your communication, that is evaluated and can be used by the court when there are allegations that a person has been hostile or derogatory, but it does cost money, but there is a possibility that you could get a grant that would pay for your portion. So if you would like that, I'm happy to order that as well, so that I can be sure that Mr. Phillips is upholding his end of how he is to co-parent in a friendly, non-hostile manner and environment.
I have two questions.
Okay.
The first one would be, I would like to know how Chad and Grant feel about that program. I might have already put in my input, but the second question and how I feel I could use a little help with these situations. I feel very sort of, I apologize for not having better words, but attacked for having called the police under these circumstances, and that it's been considered as escalating. And I would like to know what would be when I'm in like the situation in the bar, in this situation, when I'm afraid and I can't just go inside and watch TV, like what should I do if not calling the police when I'm in distress and worried? And those are my two questions.
Okay. So I did not suggest that if you believed he was DUI, getting into a car, driving, that you escalated anything. I did not
Right.
make that statement today, to my knowledge.
That
You
was great.
said that I had previously requested that things before they escalate, we come back into court, and I'm sure I probably said that. What actually your call to the police and the report shows your actions, but it also shows that no concerns were or any further action was taken by law enforcement. So it can work both ways. It just happens this time it worked in his favor. It's just like DCF reports. I encourage people not to make malicious DCF reports against one another, but I, as a judge, cannot order someone to not make a DCF report. And that's sort of what you're asking me here now is I'm not going to order that you cannot call the police when you believe that someone is in danger. So I'm not going to order that you don't. Just like I wouldn't order that someone not call DCF if they think a child's being abused. But so I don't know what, again, if we had Wizard or some form of communication, you would write to him. I don't think you should pick up the car. It sounds like you have been drinking. It's probably best that you not come to the house. You can get it in the morning, or Carbon can get it in the morning. Something like that, that would document and reflect your concern that he's drinking. And then, those kinds of things, if you don't call the police, if you do, you do. If you don't call the police, you're making a record that you're routinely bringing up the same issues, no matter what they are, over and over as it relates to co-parenting of Carbon. So that's a way to document it.
Wait, yes.
I just want to do the right thing.
So she's asking Mr. Brazil what your position is about communication through a format that is designed for parents who have difficulty communicating and co-parenting.
We would ask that the court not order that. While Ms. Blakey does likely qualify for a waiver of the fee, Mr. Phillips does not. I think both parties would acknowledge that, but for this instance, and really the latest record in this case, going back to the agreement that they reached in November, it does show that we're trending in the right direction. I don't think we're at all in the position that we were at other points in this case where there was persistent, continual contact and disagreements about who said what. I think this motion ultimately kind of boils down to this one incident on this one day. And but for that, I would say it has been quiet between the two of them. They've been co-parenting well. Things are going well. And so we would ask that the court not put that other layer on there because but for this, I think it's going okay. And I don't really know that our family wizard would stem or stop some of the same things we're already dealing with. I think we would just be here with communications in a different form, but I don't think it would stop people from coming back to court.
All right. Well, just keep your own documentation then. And Mr. Brazil, I'm just going to say to your client, I know you've talked to him, anyone that is an adult child of an alcoholic knows the lifelong impacts that can have on a person. Anyone who is a loved one of an alcoholic, and eventually any alcoholic knows that they get sick and tired of being sick and tired, and that all it does is bring you distress, anguish, and eventual death. So I just hope that if your client is struggling, and people can be struggling for all kinds of reasons, and he's using alcohol to cope, that he reaches out on his own and gets some kind of help, because I will say, there is longstanding conflict between these two. And I'm happy to hear what you've reported, and Ms. Blakey's shaking her head, so I believe it to be true. But I do think part of it is because Ms. Blakey has made tremendous improvement in her presentation, in her restraint, in her, motivations. He can have a lot of resentment over this and that, and what he's had to go to court for, or he can let that all go and put that behind them and focus on the best version of himself. She work on the best version of herself, and then Carbon will be forevermore the beneficiary of all that. So that's all I'm going to say with regard to that. The only other issue I have to address, though, is with DCF. And that is when the arrearage is resolved or absolved, or whatever you want to say, when there's no longer any arrearage in there at zero, and they're sharing custody. I know you still have to do a worksheet of some sort, unless they have come up with a shared expense plan and budget. So I don't know what the next, again, if you go back and look at the notes with Murphin, the notes in this case, there's a long history. There had been I did not impute any wages to her. Even when he had custody, she didn't pay support. Then Judge Murphin took the case and imputed wages, and then I asked him not to because of her physical and mental health. There were issues that I believe prevented her from being able to work full-time or long-term. And again, this wasn't a divorce with a lot of assets where she had a lot of money or anything at her disposal. So I kind of intervened there, and she wasn't ordered to pay anything. But then I think when they did this shared, or something happened, that then he was ordered to pay until we must have done some imputing. I think I've gotten this wrong because that can't have happened quite that way, or there wouldn't be an arrearage. So why don't you tell me where we're at on child support and what's going to happen going forward, though, so that the parties have an idea of what they're looking at, since it really is kind of out of my hands when it's a 4D case.
So, Your Honor, it's my understanding that back, let me look at the date. Looks like it was file stamped in November of 2024. There was an order where you found that mother owed father arrears in the amount of $2,778. At that time, a child support worksheet was entered, mother at $0, father at $3,239 a month. So it showed father had the obligation, and I should say that had a shared expense and shared parenting plan on that child support worksheet. And then he had the obligation of $342 a month. And that was for $1 offset against mother's arrears. So that would have been 8 months ago. So 342 at 8 months is $2,736. So, I mean, we're really looking at about $40 left that need to be paid off before that dollar for dollar offset is going to go away. So obviously that'll happen in August, and Mr. Phillips will now have that child support obligation that will have come due. However, I will state that the last part of that journal entry said that the court was considering not having father pay child support, as he didn't feel it was equitable in this situation.
Okay. And that's because I think there was a considerable period of time where no child support was being paid by mom, and no income was ever imputed to her. And that's still really a question, I think, especially since legislatively the courts have now been given the discretion to not impute when it's not equitable. I may have not imputed before there was actually a change in the child support guidelines. I think what I thought might happen is that if she got Social Security disability, sometimes if it's SSD, and you can correct me on this if I'm wrong, but there will be some money allotted for a minor child that is a dependent, and that can be utilized as in lieu of someone's payment of child support. That never happened with her. I mean, she's never secured that disability that she filed for quite some time back.
So the issue with that would be, in this situation, Mr. Phillips is the one with the obligation. So even if Miss, and they have shared placement. So if Miss Blakey does qualify for SSDI and the child does get auxiliary benefits, those are going to go to her in her home. The only way those benefits would cover child support is if those auxiliary benefits were on behalf of Mr. Phillips for a disability he had. Then if the child were receiving auxiliary benefits for him, that could satisfy a child support obligation.
Right. But what I mean is, back when this case started, back in 2018, there was, I don't know, 7 years, 8 years of no child support being paid by her. Part of the reason that I was holding off was that I thought she might get some disability, and then that could be money that could be paid to dad. The dad never got.
Okay, I understand now.
And I can't remember where this $2,778 arrearage came from, but I don't think it was a monthly child support arrearage obligation over that length of time. So then when they more recently became shared, that's where the 342 came up. And because she's still zero, and then I was like, well, the only thing equitable is that it'll go against her so she doesn't owe money either. But now we're at a point where he's got to pay support for the next now 2 years, not just year. So till the child's 19 on a child that she essentially paid no support for. So I'm not sure. I mean, the guidelines say what they say. Mr. Brazil, we're kind of where we're at, where now your client, if it hasn't been reconfigured, as far as wages, at 342, and if we had some kind of Social Security, that could be some kind of income assessed to mom, but we don't. So it would have to be minimum wage imputed, which we haven't done, which means that your client is going to start owing 342 that presumably goes directly to Miss Blakey every month.
Which, so I would highlight one of the issues that we were here to read, and Ms. Hawk kind of alluded to this in the journal entry, that it is ultimately not the intention of the court to require petitioner to pay respondent child support, given the history of this case, such as a result the court finds to be inequitable. I think that is still very much true. I mean, Mr. Phillips had primary residential custody of this child for so long, and then to now say he not only did not collect on that, then had to pay down Miss Blakey's arrearage for her, and then also now has to pay an award because she doesn't take any action to get income. I think that's highly inequitable. I recognize the guidelines say what they say. I think the court can make discretionary adjustment to zero out his obligation and say, like, nobody's paying anybody. That's the agreement of the parties. I would ask for that, some sort of an adjustment to where there's just no money changing hands. I mean, part of the reason why we're here is Miss Blakey's car wasn't working and she used the car that Mr. Phillips is paying for. I mean, it's not an equitable scenario for him to now be also paying her 340 or 342 every month for the next 2 years on top of everything he's already done.
What is Carbon planning to do after high school? Do either one of you know?
He wants to go to school. He's been talking about auto mechanics. Possibly.
Mr. Phillips says he's taking college classes too. Are you paying tuition for that?
Yeah.
And Mr. Phillips pays the tuition for those courses he takes in high school.
I'm not aware of any classes.
He's enrolled in one Butler County class this year.
He's enrolled in a Butler County class this year.
Okay, I haven't been informed of that.
You've been informed.
I wasn't.
Mr.
aware
Phillips
of
is
the
paying for
position
it.
that
He just got the bill, apparently.
The counselor sent up last year.
It was a school counselor decision.
I just
Ms.
informed
Blakey,
of this stuff.
Ms. Blakey, what would be your thought about the 342 being paid into a savings account for Carbon for college or VOTEC school? Would you be?
I think that would be wonderful.
Okay.
Paying for everything.
We need a new calculation. My client, he can't afford that. He cannot afford that obligation, given all of his expenses. He has to give Carbon food money at mom's house, gas money. He's paying college tuition. He's paying all the things.
I know. Mr. Brazil, do you understand though, with 4D actively being involved, I can't just willy-nilly do things. So
Your Honor, if I
we're
may.
gonna have to have a hearing on what's equitable, what's not equitable. I really don't want to cause these people to rehash more and have more angst, but I'm not sure what to do exactly. Yes, Ms. Hawk, I know you're fairly new, or you're new to me with DCF and certainly this particular case, but can
So,
you shed some light here?
yeah, first, I don't know that it necessarily matters entirely for you guys, but DCF has an assignment of rights for both of these parties, which is kind of unique. But at this time, since they have shared placement, they're both receiving mandatory services for this child. And the guidelines do allow for an overall financial adjustment condition to, for at the court's discretion. And so that's always an option. And at this point, I wouldn't object on behalf of the state if this was a zero child support order based on the facts, as long as there's a court finding or that it's in the best interest of the child. Generally, it would be my position. I understand Blakey has a lot going on. Generally, it would be my position in any other case that she be imputed at least $10 an hour full time. It looks like the parties, I'm assuming, are alternating taxes, is how the last child support worksheet was calculated with shared expense and shared parenting time. That would give an obligation of $186 a month payable by father, and then it would be at your discretion if you chose to give father an overall financial adjustment condition in any form or fashion to that 186. That would generally be my stance. I know the court hasn't historically imputed mother at a wage, but that's kind of where I'm at, and from an agency standpoint.
May I respond
Yes,
to a few things?
Sure.
First, I want to start with my situation. I have multiple times tried to, I've proved that I worked with a disability lawyer, attorney. I work with Parmalee. Also attending school right now, and I get help with vocational rehab. I have a wonderful case manager who helps me through there and has agreed that it is best for me to focus on school, because the trying to balance motherhood and school and work is not based on my health and really I apologize what the word realistic, my ability to balance that. I haven't worked since 2020, and so I haven't filed any taxes. I haven't qualified to file taxes, and even when I did work in 2020, I didn't make enough to file taxes at that time.
So how do you
And
feel about
as far as,
go ahead.
I'm sorry.
Go ahead.
As far as with Chad paying, he does a business. He has 2 employees and might have a new one. I want to also be clear that he does provide financial help when Carbon stays with me. He provides Carbon's gas. He's going to provide the funds so Carbon can go to school, clothes shopping, and so I don't know if I have much opinion on. I mean, he does help, and but he does also have to help. I do have food stamps. I get $15 a month for Carbon in cash assistance because that's all I'm entitled to. But he also does have to provide that assistance still. I do have support. I do have a car. But I just wanted to make a note of Chad's employment situation, that he does own a business, but also that he does help financially, Carbon, while he's in my household.
Okay. Do you have an objection to me making an adjustment and abating his child support to 0 at this time?
So, neither of us would be obligated to pay child support.
Right.
I do not object.
Okay. So
I would be okay with it.
all right, I'm going to find that there should be a financial adjustment to father, and impute is indicated just for purposes of the adjustment. I'm not actually making a finding that I believe that she could work a full-time $10 an hour job. I've never been of the belief that she could function and make her health, financial or physical or mental, a priority with a full-time job and then trying to parent. So, but we can do it for purposes of the worksheet, and I just don't want to Ray judicata on the imputation because I'm not really making that finding, but make that adjustment so there's 0, keeping in mind a couple of things. One, just like custody and parenting time, child support's always modifiable by the court. So the court has ongoing jurisdiction if something should change. Somebody wins the lottery, somebody gets a windfall, something. If it's in the best interest of the child, the court can always go back and review and modify, at least forward. Secondly, if you got child support, at least Ms. Blakey, for you, for sure, and perhaps even Mr. Phillips, it sounds like the state may very well keep the money based on what you're receiving in benefits, and it wouldn't be something that you would get in your hand necessarily anyway. Just a comment there. So, Ms. Hawks, you've been very patient. You've been very helpful. If you wouldn't mind drafting an order so that I can make the findings and we can 0 out this case for now anyway, I would appreciate it. Obviously, any party has 30 days to take an appeal. That includes DCF if they desire. That includes Mr. Phillips. That includes Ms. Blakey on anything that I've ordered today, but also on the child support if desired. I'm not going to schedule any new hearings. Hopefully this next couple of years are good ones for Carbon, are good ones for both of you. You're going to blink your eyes and he's going to be an adult on his own, starting his own family. So, is there anything else though that needs to be taken up now? I do have a 2:30 case that was scheduled to start, but is there anything that I have not ordered or referenced that needs to complete what's before the court today?
Judge, you want me to do a journal entry as to the custody pieces of what the court ordered?
You know, you have every time and your client's paid for it, and I appreciate it, but it's kept the file documented, and I would appreciate it.
Yes, Judge.
All right.
Your Honor, I have a couple clarifying questions.
Yes.
I can do the child support worksheet 2 ways. Would you like Miss Blakey's income to stay at 0 and do a $342 overall financial adjustment condition, or would you like me to place her at $10 an hour and do a $186 overall financial adjustment condition adjustment?
I think it's harder for me to show an adjustment of $342 than it is $186. But, and I don't mind assessing that 10 because she's not going to be paying anything, but she's not receiving anything. But I don't want a court order that makes a finding that I found that she's capable of working 40 hours a week at $10 an hour.
I can clarify in the order then.
Perfect.
My only other thing is signatures. Would the parties like me to submit this to them for signature, submit it with waived signatures or Rule 170?
I will probably just take a look and then say you can electronically sign if that's okay.
Okay. And do you have Ms. Blakey's email?
I believe it's in our file, yes.
Okay. So Ms. Blakey, she'll, like we've done in the past, she'll send it to you. If you don't object to it in 14 days, she'll file it with me and I'll sign it.
So it's
Okay.
not going to, a no on, I don't understand all of this very well, but it's not going to impute the $10 and assume that I can work.
It's going to show an assessment of 10 for income on your side, but it's not going to show that I'm finding that you should be working right now a full-time job at, usually it's minimum wage, sometimes 10, whatever the going thing is. I'm not going to make that finding that you should be doing that right now, but for purposes of the worksheet, I'm just going to adjust the 186 instead of 342 with you at 0. So it's just a matter of computation of how I'm going to assess it, but you're not going to owe anything. And I'm not making a finding that anyone can assert later that I have made a finding that you're capable of working today.
Okay.
Okay?
I very much appreciate that.
I know that's clear as mud, but that's how I'd like to do it.
If
I
I
will
could
do my
just say,
best to clarify that in the order.
Okay, very good. All right.
just
Yes.
want to
whatever.
say that it's very, I really appreciate you sort of validating my health state. That's so helpful mentally, but also in my day-to-day life and how I go about getting help. That helps a lot.
Okay. Well, I'm very
Thank you.
proud. Okay. All right. We
Oh
are-
my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He's an interpreter.
I need an interpreter when I cannot express myself somehow.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in for You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so
No case left. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.